My name is KAUSHIK JAIN. I am an internet Vakilji official. Today I am going to say a few lines about right to information. The very existence of a democratic system depends upon the equal rights for its people, freedom of speech, fair trials, and tolerating the views of minorities. In the same way, the government is responsible for the interests of its citizens, so it becomes essential that the government or its representatives freely express their ideological views before the public. There has to be transparency in the working of the government, where the free flow of information is must for spreading awareness regarding the rights of the citizens of a democratic society. Thus, the right to information, that is a part and parcel of freedom of speech, is indispensable for ensuring transparency and accountability of good governance. The Freedom of Information Act 2002 was enacted by the Indian Parliament to promote transparency and accountability in the administration. Later on, this act was repealed by the new enactment, the Right to Information Act, made by the legislation of the Parliament of India. The Right to Information Act was passed by the Parliament on June 15, 2005 and became fully operational from October 12, 2005. Under this new law, the Indian citizens are empowered to seek any information from a public authority, making the government and its functionary more accountable and responsible. Now, what is RTI? The right to information is commonly known as RTI. The right to information is a part of the fundamental right of speech and expression enshrined under Article 19 subclause 1 of the Indian Constitution. The right to information has been made a statutory right through the Parliament's enactment. This act is often termed as revolutionary, as a common man can demand any government agency to furnish information by using this right. Further, this act mandates timely response to the citizens' request for government information. Section 2J of the RTI Act defines right to information, which means the right to information accessible under this act which is held by or under the control of any public authority. The rights which are available under RTI Act are: seek any information which is held by any public authority, take copies of government documents, inspect works, documents, records of government, take notes, extracts or certified copies of government documents or records, take certified samples of government work, and obtain any information in the form of disks, floppies, tabs, etc. Now comes to the point of objective. The very objective making the right to information a statutory right is to secure access to information for the citizens which is under the control of public authorities, to empower citizens, promote transparency and accountability in the working of the government, contain certain corruption, and make our democracy in the real sense is the basic objective of the Right to Information Act. As it goes without saying that any informed citizen is better equipped to keep necessary vigil on the governance and make them more accountable to the government. The Act is an initiative towards making the citizen well informed about the activities of the government and all the public authorities under it. Now, who can apply under RTI? It's Section 3 of the RTI Act empowers citizens to have the right to information. But any person can avail this right to receive information under 6th section of this Act, as the ambit of Section 6 is wider than Section 3. This was also held in the matter of Chief Information Commissioner vs. State of Manipur. Now comes to the point of public authority under the RTI Act. Public authority is defined under Section 2H of the RTI Act. It states that any authority or body or institution of self-government which is established or constituted by or under the Constitution, by any other law made by the Parliament, by any other law made by the state legislature, by notification issued or made by the appropriate government, and includes any body owned, controlled and substantially financed, non-governmental organizations substantially financed directly or indirectly by funds provided by the appropriate government. Now comes to the point of appropriate government. Section 2A of the RTI Act defines the term appropriate government. It treats as appropriate government in relation to a public authority which is established, constituted, owned, controlled or substantially financed by funds provided directly or indirectly. Here is an example of all the government departments or agencies, bodies under the central or state government who could come within the ambit of this act. Government departments, municipal corporations, government schools, etc. Whether private bodies are covered under the RTI Act, only those private bodies or organizations which are owned, controlled, or substantially financed by the government are directly covered. Other private organizations where if the government department is allowed to access information by means of any act, then the same can be accessed by the citizen under this act through the aid of that government department. Government departments that are exempted from this act are there are in total 20 organizations that are exempted, as section 24 of this act states that the act shall not apply to certain organizations. These organizations are all concerned with the country's defense, intelligence, such as RAW, BSF, CRPF, CISF, Intelligence Bureau, National Security Guard, etc. Now there are certain criticisms regarding the Right to Information Act. The Right to Information Act makes the right to information as a tool to check upon the misuse of discretionary power of administrative authority, but it suffers from several drawbacks which weaken the position of the right to information. The drawbacks are: Section 2H defines the term public authority, but it does not give a comprehensive and exclusive definition of public authorities, which might create confusion. The term public authorities includes non-government organizations which are funded by the government either directly or indirectly, but there are some NGOs which are funded by the public directly or indirectly. Then the question has been arising whether these NGOs falls within the category of public authorities or not. Temples appeared not as a public authority because they are funded by the trust, but in many cases the Supreme Court considered temple as public authority. So here also there is a clear picture in the act where the temples considered as a public authorities or not. Another loophole in this act is the absence of contempt provisions. This stated that the Information Commission shall be binding, but the provisions of the contempt of court is absent, due to which it cannot force or compliance to the public to follow the rules. The absence of contempt of court make the non-compliance of the order passed by the Information Commission. There must be provision inside in this act. And there is no penalty under the appellate authority. The applicant should receive the information requested in the RTI application within the 30 days of receiving such application, and within 48 hours in case of life and liberty as per section 7 subclause 1 of the act. But if that limit exceeds or in no limitation time period this work not done, then there is no provision or concept introduced. It is necessary because it makes the whole process lazy and wasting without any penalty. It provides that the servicemen also become the central public information officer, even if they don't have knowledge about that, and work still they appointed as the additional duty, as the dealing with the RTI application is necessary and the relevant information is required, and dealing with the applicant is very crucial and important, but the qualification of central public information officer is not given and not mentioned anywhere about the qualification. And training should be provided to the freshers persons and appellate authority, and review them from time to time about the amendment. Test along with the training should be conducted so that they can get information and knowledge. There are various other loopholes in this Right to Information Act which create a hurdle in the better administration and to fulfill the objectives of the acts, which ensures that the information must be delivered to the public within the 30 days of application, and if the public officer fails to provide information within the prescribed time, he must be punished. Thank you.